Signature requirement effective from July 10. What does it mean? Welcome to the Law Offices of Mary Kennedy. So there was an interim rule that's going to be effective from July 10th on the signature requirement. Is USCIS not going to accept the scanned signature? No, that's not the case. Still the scanned copies are fine. However, there is a wet signature requirement that has to be done, and the change here is going to be more like USCIS is going to deny the petition later at a point when you have applied for it. Say for example, H-1B has been applied as a petition within the 60 days grace period, and you are in status and you start continuing to work for the other employer, everything goes on fine. At one point of time, USCIS identified this is not the right signature that has been part of this petition that has been submitted like 6 months earlier to it. They are not going to issue an RFE, which is the regular pattern they follow. Now it's going to be a direct denial. So this can happen in various applications as well. See, the 539 is an application or an EAD card. Most of you had been waiting on a H4 EAD for almost like 8 months, 9 months. You are assuming my processing timeline is current and I'm going to get the card sooner or later. Then you notice that USCIS denies the application directly and the fees as well has been gone. And more than that, the time that you had been waiting on this for the 9 months, 6 months, and you could have in some cases even having an employment continued. All those are going to be very highly significant changes, and it might cost more than what you really understand. So please pay attention. It's not like original signatures are needed in all the forms, which was prior to COVID. However, after COVID period, still USCIS considers the scanned copy of the signatures on the form. The requirement is a wet signature that has to be signed. See, we also have to understand when you have a signature on any of those forms, it means that you are complying to whatever the terms and the compliances. That is part of the process. It's not just putting a signature in somewhere, agreeing to the government that this is what I am giving these documentations. In a 485, you answer the question yes or no. Have you ever been arrested? And then you say no. Then your signature comes at the end of all the pages of the form, means you are giving an answer, understanding what you have written down on the form. So these are all look simple as such, but please pay attention to anything that has been applied for. See, already with the changes that happened in the fees after November, USCIS doesn't accept checks, but still we do go through different experience of filings. That's what all about being an immigration attorney and a firm. Some of them still had used a check and they waited and twice it got rejected. They don't have a proper reasoning, and then later on they are out of status when the B2 should have been filed prior to the 60 days period, or an F1 change of status has not been filed properly. Any immigration comes with a cost that is attached to it. So please pay attention to what you're doing and learn the process and do it in a way it's more efficient for your continuity of stay. Thank you. Thank you for watching.